Prezentarea e în engleză, dar o să încep în română. Numele meu este Alexandra Cohutiu, sunt avocat la Laurențiu și Asociații. Sunt managing associate și o să vorbim puțin despre anumite probleme sau piedici sau cu care se confruntă societățile în viața de zi cu zi, începând cu crearea firmei și mergând la setarea relațiilor cu investitorii și apoi despre un subiect foarte dezbătut în prezent, respectiv referitor la regulamentul european cu privire la protecția datelor cu caracter personal. După cum spuneam, e în engleză. Dacă sunt întrebări sau nelămuriri, pot să vorbesc și în română. As I said, there will be two parts through my presentation. First of all, we were going to talk a little bit about the legal challenges, legal issues, which companies, startups or not, face, starting with their incorporation, moving on to the protection of their IP rights, which often can be the most valuable asset of a company, especially for startups, but for any company. IP rights are a very important and asset which needs to be protected. Then we're going to go a little bit through what structuring an investment deal supposes, and to shareholders' agreements, which are a big part of and very important part in the investment deal for growing your company. And then we will talk a little bit about data protection compliance. As I said, for a startup, it is really important to have a company incorporated as soon as possible. In Romania, you can choose between two main popular company types: the limited liability company, which is which supposes a small amount of minimum initial share capital, 200 RON. That's a little less than 50 euros, but it's more restrictive because the main focus is on the relationship between the shareholders and the persons you are associated with matters. Therefore, there are restricted rules regarding the sale of your shares to third parties, and it's more difficult to sell your shares to third parties. And on the other hand, you have the joint stock company, the SA, which supposes a larger amount of minimum initial share capital, but and somewhat higher administration costs, but it has more flexible rules. It's easier to transfer your shares. It's easier to structure investments. You don't need to go everything to the General Assembly. For example, if you want to sell your shares in a limited liability company, you need the approval of 75% of the members of the General Assembly. In the SA, you don't need that. You can simply sell them. After you have a company which is incorporated, the most important next step is to protect your IP rights. For a startup and for any company as well. As I said, IP rights are the most valuable asset, and it's the first thing the investors look into when they decide if they want to invest money in your business, in your idea, in order to help you grow. So you need to ensure that the IP rights are owned by the company, not by the founders. In Romania, you have the IP rights of the creator of a computer program are recognized and they are protected. However, you don't have protections for ideas or concepts. You'd have protection from the law only after it is materialized in a computer program, meaning any expression of a program or part of it, application programs and operating systems expressed in any language, whether in source code or object code. Before it is an idea, you can protect it by using NDAs with the persons you are collaborating in order to develop the idea into an actual program. After it expands and more people get involved, you need to make sure that all the IP rights for the content which is developed lies with the company and is transferred to the company, and the company is the one who owns all the rights. For this, you will have to include in all your contracts with your employees or collaborators IP assignment clauses which ensure that the ownership of the IP rights is effectively passed on to the company. Also, NDAs are also advised because of the confidentiality issues. As I said, another very important step in the life of any company is finding investors and finding the money in order to grow it and to make it a lot bigger. At the point when you find an investor who is interested in investing in your company, it is essential to make a term sheet where you need to, which should include all the key points of your deal, which will serve as the basis for the drafting of the actual investment documents. Usually the investors are concerned with economics and control. Most investment documents will include liquidation preferences, anti-dilution clauses, tag-along, drag-along rights, and protective provisions for the election of the board of directors and for a specific decision which can influence the life of the company. The liquidation preference, as I said, it determines the payout order in case of a corporate liquidation, and it is used in order to specify which investor gets paid first and how much they get paid in case you have a liquidation event, which can mean bankruptcy, but it can also mean the sale of the company. When you will sell the company, the liquidation preference it determines who of your investors get paid first and to what extent. The anti-dilution clauses are used in order to prevent investors and to protect the investors from being diluted in future issuing of stock. These are usually materialized in rights of first refusals for the investors, in case the company issues stock and they have the right to first buy the shares which are issued during that share capital increase. Tag-along and drag-along clauses. Tag-along rights protect the minority shareholders. In case the majority shareholders want to sell their stakes, the minority shareholders have the right to get into the deal and to sell also their stakes in the same terms and conditions as the majority wants. And the drag-along, you protect the majority shareholders. In case they want to sell their stakes, if the majority shareholders decide to sell them, the minority shareholders will also be obliged to forced to join the deal. In case, for example, the one who wants to buy the shares, the company, wants to buy it 100%. And in these cases, if there is a drag-along right, the minority holders will be forced to join the deal. As I said, there will be a lot of, the investor will want to have also protective provisions in order to get as much control as they can. That's why it's very important to focus on for these protective provisions to imply to help the investors, to give the investors through these protective provisions control over major things which happen with the company, like selling the company, selling most of the assets, but to keep the operational part with the founders and the decisions regarding the operational matters with the founders. All these things usually are included in shareholders' agreements, which are not public and are more detailed than the articles of associations. The articles of the associations go to the Chamber of Commerce and the Register of Commerce and are public. while shareholders' agreement can be kept private and can be more specific. As I said, one of the most important and really debated topics nowadays is the data protection compliance. Data protection is not dependent on the size of the company. The fines are the same, irrelevant of the how big your company is. And we have nowadays in Romania and all over the European Union data protection internal regulations, but what this new EU regulation, which will enter into force in May 25, 2018 will do, is that it will uniformize everything, and that we will have a single set of rules throughout the European Union with really, really high fines, up to 20 million euros. This regulation applies to all EU organizations, and it's irrelevant if you process the data here or abroad, if you are an EU company. And also, it will apply to non-EU companies which process data of EU individuals. In these cases, the non-EU companies will have the obligation to appoint a EU representative, which will be based in the European Union, and they need also to understand the impact and to determine an approach for the compliance. The definition of personal data was also very much expanded. It applies to anything which can lead to the identification of a person, including online identifiers, such as IP addresses, or anything in particular which can directly or indirectly identify a person, a data subject, how it is called in the regulation. The regulation stipulates some principles. First of all, in order to process and collect data, you need to have a lawful basis for it. It can be consent, it can be a law, it can be a contract, but you need to have a lawful basis for the processing. The data which is processed needs to be purpose limited for a purpose. You need to collect only the data you need for the purpose. I don't know, you're collecting, for example, you have CCTV systems, and you're overlooking your restaurants. You're collecting images of persons and their actions. You're collecting them in order to prevent fraud, and in order to identify if there are robberies in your restaurant, for example. Data needs to be minimized, so you don't need to, you only need to collect the data you need for the purpose you're collecting it. And the data needs to be accurate, and if it's necessary, always up to date. You need to store it only for the time needed in order to identify, in order to achieve the purpose for which you're collecting the data. For example, in the example with the CCTV system, you will probably retain it for 3 or 4 days. If you're collecting footage from an ATM, for example, you might want to keep it for 2-3 weeks in order for a fraud, because not in all cases these kinds of fraud are identified in a short amount of time. You need to ensure that there is security, that the data is secure, and you need to make everything you can in order to don't have unauthorized access to it, and to prevent accidental losses or breaches of the data you're collecting and storing. And very important, and this is quite new, the principle of accountability, which refers to the fact that not only you need to comply with all these things which I said, but you also need to prove that you complied and to have this documented. So in case there is an allegation that you don't comply, you have to be able to prove, and to prove this with documentary evidences. The main obligations for companies, and the most important one, I think it's the fact that you need if you base if you base your processing of the data on consent, it's important to know that this needs to be freely given, and it needs to be informed, explicit, and specific. You cannot rely on silence, pre-tick boxes, inactivity. It needs to be explicit. And it needs to be as easily revoked as given. Informed. You need to provide everyone whose data you're processing and collecting clear and concise information which ensure the transparency of your processing. This means you need to provide in a very clear and concise way information which is spread along more than 6 pages in the regulation. It's information regarding the purposes, the recipients, the retention period, and the specific rights which individuals have. You need to provide this information irrespective of if you're processing data based on the data subject's consent, or if you're processing it on other legal basis, in case in which you need to provide this information notice as soon as you start collecting and processing their information. A new concept, privacy by design, and this privacy impact assessments, this go hand in hand with the accountability principle. Because privacy by design means to the fact that you have to implement technical and organizational measures to ensure that you comply with the data protection, and you need to document this. And the privacy impact assessment, which identifies and minimizes non-compliance risk. This is not mandatory. It's mandatory if you have more than 250 employees, and if you collect and process information which can have high risks for the rights of individuals. But it's not really defined what high risk means. In case you collect information from a lot of people, it's usually high risk. This privacy impact assessment needs to contain a description of the processing and the purposes, to assess the need for it and the proportionality of it, and you need to have also a list of measures which ensure your compliance. Data protection officers are the persons inside the company or from outside the company which deal with data compliance. That doesn't mean that the company does not have any more liabilities, but you have a person which handles everything. It's optional with the exception of the cases where the law provides that it's mandatory, especially in cases you collect special data like genetic data, health data, and so on. You need to keep a record of your processing activities, which also goes hand in hand with the fact that you need to document that you're complying with the regulation and with the rules. There's also the obligation to notify any breaches of the security for personal data. The fine actually is 20 million euros or 4% of the turnover, in case you fail to notify this breach. And you need to keep also a record for it. For keeping records, the fine is 10 million euros. Or 2%, whichever is higher. As I said, there are specific rights to the individuals to be informed. I'm not going to go again over it because we talked about it. To access the information, if they want, they can request you to give them access or to provide them some information. You need to do this free of charge and within 1 month after the request, and it's mandatory. To rectification, if the individuals find that you have incorrect data, they will notify you and you will have to correct it, also free of charge, also within 1 month. Right to erasure. This right to erasure is a little bit limited to those cases where you don't have a legitimate purpose in order to keep that data. For example, for public interest, for health issues, for freedom of speech. But as a rule, there is the right for the person to request to be forgotten. The right to restrict processing, that's also hand in hand with the right to erasure. It's almost the same, but it's it can ask you to not process it only for some cases. The right to data portability. This means that if you have data from an individual, it can ask you to transfer all his data to a third party, and you will need to do this free of charge. And within 30 days, of course. You have an extension, a possible extension of time of 2 months. But that's only in exceptional cases, and if the amount of data you need to send to the third party is very large. But the rule is everything you need to comply free of charge in 30 days. And that's also the right to object to the data process, for the data processing. They also have the rights to lodge a complaint. They have also this right exists also in the Romanian law. Now, to lodge a complaint to the supervisory authorities, which will come and check if they're right, and if they're not right, if they're right and you're not complying with the rules, they will probably set a fine. They also have the right to compensation in case they suffer material or immaterial damages resulting from non-compliance with the regulation. And they also can bring claims for non-pecuniary loss, like moral rights, or moral loss. As I said, the fines, some contraventions are for 10,000 million euros, or 2% of the global turnover, whichever is higher. These are actually the ones for not keeping record, but for not keeping regular record, not when you're processing sensitive data, when you have the other fine, which is 20,000 million euros, or 4% of the global turnover, whichever is higher. This goes for not giving clear information notices, for not having a legal basis for it, for not respecting the rights we talked about, and for not ensuring compliance, and for not having all these privacy impact assessments where there is needed, where such privacy impact assessments are needed. As a to-do list, it's approaching very fast, and it's very important to ensure that you comply with it. I think it's very important to know which are the rules. Then it's very important to know what kind of data you collect or process, in order to know which kind of rules apply to you and what you need to do. Then you need to review all the data protection policies. Most of the companies have these kind of rules and internal regulations. And you need to ensure that these are also, your employees are trained in order to comply with the regulation, because they are the ones which have access to the data on a daily basis, and they need to know the rules in order to comply. Consider whether rules on children are likely to affect you. Parental consent for data regarding children under 16 is required. And it needs to be also explicit, like the one in general. For data which is collected indirectly, ensure that notice is given in appropriate time, and you need to assign it's good to assign responsibility and have a budget for the data protection compliance within your company. And I'm thinking this also from the fact that you need to ensure security of the data, and you need to make everything you can in order to prevent security breaches, accidental loss of the data, or accidental access to your data, unauthorized access to your data. Thank you that you stayed until this long, until this late.
Voi încerca foarte scurt. Acum mă gândesc că dacă era în prima parte, tot cu acesta nu cred că se mai termină la câte reguli și amenzi ne-ai spus aici. Mă gândesc oare UE ce va face cu atâția bani după ce ne amendează pe toți? Pentru că în momentul de față cred că niciun e-shop nu îndeplinește toate regulațiile și toate aceste mențiuni care le-ai spus mai devreme.
Ele sunt aplicate de autoritățile locale, sancțiunile.
Deci local aici încă mai putem influența legea, să înțeleg.
Păi nu putem să le influențăm. Ce se poate influența, organele competente au putere de apreciere până ce amendă aplică.
Dar nu e din start 20 de milioane.
Dar nu există un minim, ele sunt prevăzute, sunt categorii pentru care amenziile sunt 20 de milioane de euro sau 2%, sau 4%, sau 10 milioane de euro sau 2%. Dar există niște praguri. Praguri nu sunt anumite puncte care trebuie avute în vedere în momentul în care se aplică în concret o sancțiune. Referitor la gravitate, la ce fel de date sunt, la cantitatea de date.
Ok, putem să luăm un exemplu concret, era mai devreme cu Adrian Chirilă de la Fashion Days. Ei, de exemplu, în momentul când îți faci un cont, îți preiau și date referitor la, din câte știu, la mărimea pe care o porți, la haine. E un sensitive data aici, adică ei dacă preiau anumite date personale despre utilizator, că poartă mărimea 52 la sacou și 48 la pantaloni, este o dată sensibilă aceasta? Intră sub regulare sau sub...
Nu e sensibilă, că cele sensibile sunt genetice, referitoare la sănătate, CNP, dar ar putea fi...
Deci e discutabil.
E discutabil. Din ce perspectivă? Mărimea de la pantofi nu poate să ducă direct la identificare, dar poate coroborat cu alte date, poate să ducă la identificarea acelei persoane.
Bun, acum oricum când pe e-commerce, când un utilizator își face cont, trebuie să-și, în unele cazuri, să-și introducă și data nașterii, ceea ce devine mai personal.
Data nașterii este sigur.
Ok, deci pentru cei care aveți acum mandatory acel field, dar trebuie
e și acum.
Da, înțeleg. Doar
că nu este interzis să procesezi aceste informații și să le colectezi, doar trebuie să respecti.
Și pentru a respecta toate regulile acestea, există un plan concret sau e doar pusă legislația și fiecare trebuie să adapteze în modul în care reușește cu jucătorii din piață, cum ar fi voi pe partea de legal, adică să dați advice-uri, să faceți modele de contractare cu clienții, cu partenerii și mai departe?
Da. Nu există un plan la nivelul Uniunii Europene, există un regulament care trebuie respectat, sunt anumite ghiduri de bune practici și grupuri de lucru care se fac pentru a se asigura respectarea, dar oricum el e personalizat. Fiecare chestiune depinde de ce fel de date, de câte date colectezi, de cum le colectezi, de unde le procesezi, cât le ții, ce faci cu ele și pentru ce motive. Cred că cel mai important e să se identifice ce fel de date. De acolo trebuie pornit, de la ce fel de date se colectează, de ce se colectează și după aceea văzut care sunt pașii de urmat astfel încât să se respecte toate...
Cred că și din partea de e-commerce veți avea mulți clienți după data de 25-2018, nu? 25 mai?
Cel mai probabil.
Bine. Mulțumim pentru detaliile furnizate.
Că ar trebui să avem înainte, pentru că și am început deja să avem, pentru că în 25 mai intră în vigoare și e punctul zero. Trebuie respectate toate acestea.
Bine, mulțumim pentru detalii, mulțumim încă o dată că ați participat la eveniment. Vă așteptăm la party la ora 8 și evident și mâine în continuare aici la Preacul de Business de la ora 11. Vă mulțumim și o seară plăcută!